Hello, this is Matt on the Moon Lambo channel. Stuart Alderoty, who is Ripple's general counsel, which is basically the chief legal officer for Ripple, their lawyer in-house, he has stated that the SEC picked a fight with Ripple and that Ripple did not pick a fight with the SEC. Well, let me tell you something here at the outset. The SEC definitely picked the wrong fight. I think it's already pretty damn clear that they weren't expecting the public backlash. But even when it comes to the facts and specifics of the case, it seems that despite the copious amount of time that the SEC had in preparing for this case, they really weren't so sufficiently prepared, now were they? Wanting extension after extension after extension, and then speaking out of both sides of their mouths, taking conflicting positions. It just seems like amateur hour with a lot of what's been going on with the SEC. And so there was an article that was shared by attorney James Filan, who is a member of the XRP community. So I wanted to give a shout out and credit where it is due, because that's how I came across this. And this article comes from a business magazine called Corporate Counsel. And it's titled as follows: Ripple General Counsel Stu Alderoty discusses his beef with the SEC. Now I want to tell you here at the outset, there's a chance that this video might make your blood boil. Stuart Alderoty explains, and this is a quote actually, that he believes there is a, quote, orchestrated campaign to handicap and smother an industry built around financial and technological innovation, end quote. And also, and this is super duper interesting, we learn why Ripple agreed to the recent lawsuit delay of 41 days. For those of you that may have missed it, indeed the SEC versus Ripple case was pushed back yet another 41 days. And so expert discovery is now supposed to end February 28th if memory serves. It was supposed to be on January 19th, which would have been yesterday. So we get to play the waiting game a little bit more, but why did Ripple agree to that? Well, spoiler alert right here. As it turns out, Ripple didn't actually want to agree to it. And so we'll explain why. I'll get into it, but I found that super interesting because Ripple did agree to this delay, but we found out, thanks to Stuart Alderoty, they really didn't want to. But I do want to be clear at the outset also, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So let's go ahead and jump into this piece. Ripple General Counsel Stu Alderoty hasn't shied away from expressing his displeasure with the Securities and Exchange Commission, which sued his company in 2020. Alderoty logged onto Twitter earlier this week and accused the SEC of playing the delay card, while the agency's chairman, Gary Gensler, made hypocritical remarks about the importance of bringing matters to resolution swiftly during a speech on enforcement priorities. And let me just pause here. I actually did cover that in a previous video, so some of you may be aware of this either because you heard me talk about it or just came across the article on your own. And so there's the thread's actually on your screen. I'm not going to read it right now. I already covered this. I'm just mentioning this is where some of those comments come from. And you can pause as I scroll down if you want to take a look and see what he had to say here. But I will note that in the final tweet of this thread, part of what Stuart Alderoty said was the SEC plays the delay card and uses it to their advantage. And he also said, how about publicly committing to moving the Ripple case as swiftly as possible with no more delays? And so I must admit, upon reading that, I was a bit curious as to why Stuart Alderoty was blaming the SEC for delaying the case further, when the truth was that, and I knew it because I saw the legal document, the truth is that both Ripple and the SEC both agreed to this delay. Well, there's more to it than that, and so it is true that technically both agreed, but there's more to it, and you'll see as we go through this. Anyway, so the piece continues. The SEC has accused Ripple, a San Francisco-based crypto firm, its co-founder and executive chairman and former CEO, of raising $1.3 billion through illegal sales of the company's digital asset XRP in an unregistered securities offering. Alderoty spoke Thursday with corporate counsel about the lawsuit, his allegation that the SEC is purposely delaying the case, and his decision to call out the SEC, which has declined to respond to his comments. The conversation has been edited for clarity and length. And so here's what corporate counsel said, and this is a back and forth, so there will be corporate counsel speaking and then Stuart Alderati. Corporate counsel, you were calling out the SEC a few months ago, and now you're at it again. So let's start by talking about what's going on now and where you're coming from. Stuart Alderati. The SEC brought an enforcement action against Ripple in December 2020, alleging that distributions of XRP stretching back 7 years before the filing of the complaint constituted an investment contract and therefore a security under the federal securities laws. There's no allegations of fraud or misrepresentation and market manipulation or omission. It's really a pretty technical issue under the federal securities laws. What this is born of is the SEC's failure, really a policy failure in the US, to provide regulatory clarity to market participants as to when the federal securities laws will apply to digital assets. And what we said back in December of 2020, when the case was filed, was that we were going to defend this case not only on Ripple's behalf, but on the behalf of the entire industry. The industry needs clarity. And you would like the clarity to come through orderly regulatory rulemaking or perhaps legislation. But if need be, we can get some of that clarity through the courts. But what has become more evident under the Gensler administration, even more so than under the prior administration at the SEC, is that the SEC is actually trading in regulatory ambiguity intentionally so that they can keep the industry at bay and really choke off what is incredible financial and technological innovation. I don't think it's right. I think it's unjust. I think it's wrong. It's not only hurting the retail consumers in the United States that suffered a $15 billion market cap loss within days of the SEC filing the lawsuit, but we're really ceding this innovation and technological revolution to responsible economic centers offshore, whether that be Singapore, UK, the EU, and most recently, Australia. And then corporate counsel said the following. What prompted you as general counsel to speak out on behalf of Ripple? Stuart Alderati. We're all trained as lawyers and professionals to be deferential to regulators and to not pick fights with regulators. But Ripple didn't pick a fight with the SEC. The SEC picked a fight with Ripple. And the fight is bigger than just Ripple, and there's a real injustice underlying this. What's happening is the SEC is no longer embracing a sound regulatory and a clear regulatory framework, intentionally avoiding that to advance its own jurisdiction, leaving not only the market to suffer and the retail consumers to suffer in the United States, but again, really handicapping the entire industry. So when you see a chair of the SEC give a speech like he did, perhaps in normal times you'd say, oh, that's just the chair of an agency. You expect him to say stuff like this. Nobody really takes it seriously. But against the backdrop of the broader issue of what's happening with the crypto industry and the lack of regulatory clarity in the US, it really starts to feel like something is happening here very intentionally and very strategically, and it's wrong, and I think it needs to be called out. Corporate counsel. They say, you've accused the SEC of playing the delay card in Ripple's case. How has the SEC delayed this matter? And he really cuts to the heart of the matter here. Because, mind you, just be clear, this was the third delay in this case, the third one. And this is a big one, 41 days. And all while people in the background are, is suffering too strong a word? Like, pick your word. It's not good. People are in pain, businesses, having difficult times, individuals, they've got their, in some cases, life savings stuck in accounts that they can't access. And I've talked about that before on the channel too. So here's what Stuart Alderati had to say about this. Initially, fact discovery in the case was supposed to be completed by the end of August. The SEC went to court and asked for more time to conduct that discovery. And the court gave the SEC more time to conduct the fact discovery over our objection, which was really disappointing. Before the SEC files a case, and listen to this, before the SEC files a case, they've done an extensive investigation And you would think that they would have all the facts available to them to justify the filing of the case. It's a head scratcher. If you're still discovering facts, why did you file the case to begin with? Think about that. Just pause. Think about that. They requested and received an extension during discovery. If you don't already have the facts that you need, why did you file the freaking case in the first place? Head scratcher indeed. Stewart continues. We then agreed to a deadline to complete expert discovery. And the SEC asked for more time, and we objected. The court gave them that extension to mid-January. So yeah, folks, it's true the SEC has won on those points, but we're talking about extensions. But on the vast majority, and this is a good thing, on the vast majority of things that materially matter, just from a fact perspective, and from a defense perspective also, it's very clear that Ripple's been winning all the pre-trial stuff. Like, not literally all of it, but the vast majority of it. So still thankful for that. Is as annoying as and awful and sucky as it is to see these assets get the extensions that they don't deserve. You know what? Fine. It steams my vegetables just a little baby boo bit, but the world keeps on spinning. Corporate counsel then said the following. What about the latest extension, which was a joint motion to extend expert discovery in the case? Oh, yes. And I was very curious about this because I couldn't understand why Ripple would agree to the extension and then Ripple's general counsel, their top legal guy, was blaming the SEC for the delay. I was like, why is that happening? Well, check this out. Here's what he had to say. Events just overtook. Without getting into details of what was alluded to in the complaint, it was COVID and other personal issues with the experts. There are 8 more expert depositions that need to be completed. We just couldn't get them done in the allotted time. Picking our fights wisely, we just decided to agree with the SEC that we would extend the deadline to complete the expert discovery. So that's sort of the blocking and tackling of the delay. But if you roll it back, we wouldn't even have been in this position of whether or not we can complete expert discovery during the COVID pandemic if the SEC had just kept to the original schedule that we'd agreed to when this case was filed. And so there you go. Ripple didn't want to push back again, and so they reluctantly went along. And it's also a matter of fact that had those initial extensions not occurred, all this would have been done before the pandemic was an issue, right? So it's matter-of-fact statements, right? And so I was curious. So upon reading, I was like, okay, I get that. It makes sense. Corporate counsel then said, how does the SEC benefit from delaying the case? And this is upsetting, but I think Stewart's correct. He said the following. I think this feeds into their strategy of deliberately creating ambiguity. If you go back to Gensler's speech, he said the reason they file high-impact cases is to draw other folks back from the line. Well, that's the definition of regulation by enforcement. If you have a high-impact case, and the longer that thing can hang out there without having a court telling the SEC whether they're right or wrong, and other industry participants' behavior is then chilled by the mere filing of a case, that's the definition of regulation by enforcement. So I won't tell you what the rules are, I won't tell you what you need to do to comply with the rules, but I'll file high-impact cases, like the Ripple case, hoping that everybody else gets chilled and most moved back from what Chair Gensler says is the line. And the longer I can keep that cloud over the industry, the better, without ever having to establish or carry my burden of proving to the court that I'm actually right on the law and right on the facts. That's why I think they played the delay card. So I was really taken aback when Gensler said in his speech that they're committed to moving cases swiftly and justice delayed is justice denied. Because that's not been their behavior in our case. That's why I called out the SEC in my statements on Twitter. If that's your view, then publicly commit that. When it comes to Ripple, the Ripple case, you will go forward and do everything in your power into this case as swiftly as possible and not call for any more delays. And then ultimately they ask, why do you think more general counsels are stepping up and speaking out for their companies? And Stewart says, to wrap this all up, there are a whole bunch of different reasons, but here, when we're seeing what happens what appears to be an orchestrated campaign to handicap and smother an industry built around financial and technological innovation. And you have the SEC really hampering and holding back the U.S. Leadership position in the world, and doing this in a way that I think others view as incredibly intellectually dishonest. I think it would be irresponsible not to call it out when we see it. Absolutely. And they've been calling it out, and others are calling it. And it's very clear, because again, like I've said many times, the only people on the planet that think that the SEC is in the right are at the SEC, with the exception of Joe Lubin, who is a co-founder of Ethereum. He thinks the SEC is doing a great job. Other than Joe Lubin and the asshat lawyers at the SEC, nobody thinks that XRP is actually security. Rare exceptions. Like, you find a unicorn person, fine. But there's almost none of them, because it doesn't make logical sense. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.